Okay friends, now we start with the very important topic of president. We all know that the position of the president or the post of the president is the most important and the most powerful position in the Indian democratic or the Indian constitutional setup. So to begin with, which part of the constitution deals with the president? It is part 5 of the constitution that deals with the president. Why? What is that part? The part 5 is the union executive. What does the union executive consist of? The union executive consists of the president, the vice president, the prime minister, the council of ministers, the attorney general. Friends, please remember the union executive also consists of the attorney general. It's very important because definitely in the exam this question is asked: who all are the members of the union executive? Rest are easy to guess, but attorney general is something that's difficult to guess. Okay, the president is the head of the Indian state. He is the first citizen of India and acts as a symbol of unity and integrity and solidarity of the nation. Now we come about the very important topic of election of the president. The president is elected not directly by the people but the members of the electoral college consisting of the elected members of both the houses of the parliament. Okay, and the elected members of the legislative assemblies of the states and elected members of the legislative assemblies of the union territories of Delhi and Pondicherry. Friends, it's very simple to remember as to who all form the part of the electoral college of the president. It's the elected members. It's the nominated members, the selected members do not form a part of the electoral college of the president. Okay, moving on. Thus, nominated members of both the houses of the parliament, nominated members of the state legislative assembly, members that are both elected as well as nominated members of the state legislative councils, that is in case that the state has bicameral legislature, then the nominated members of the legislative assemblies of Delhi and Pondicherry do not participate in the election of the president. Whereas where in case an assembly is dissolved, the members cease to be qualified to vote in the presidential election even if the fresh elections of the dissolved assembly are not held before the presidential election. Next, the constitution provides that there shall be uniformity in the scale of representation of the different states as well as parity between the states as a whole and the union at the election of the president. To achieve this, the number of votes of each elected member of the legislative assembly of the state and the parliament is entitled to cast at such election shall be determined in the following manner. Number 1. Every elected member of the legislative assembly of a state shall have as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of elected members of the assembly. It can be expressed as a value of the vote it can be expressed as a value of the vote of an MLA. Every elected member of either house of the parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of legislative assemblies of the states by the total number of elected members of both the houses of the parliament. It can be expressed as each member of the electoral college is given only one ballot paper. The voter, while casting his vote, is required to indicate his preferences by marking 1, 2, 3, 4, etc. against the names of the candidate. This means that the voter can indicate as many preferences as there are candidates in the fray. In the first phase, the first preference votes are counted. In case a candidate secures the required quota, in this phase he is declared elected. Otherwise, the process of transfer of votes is set in motion. The ballots of the candidate securing the least number of the first preference are cancelled and his second preference votes are transferred to the first preference votes of the other candidate. This process continues till a candidate secures the required quota. All the doubts and disputes regarding the election of the president is inquired into and decided by the Supreme Court of India, whose decision is final. Friends, please remember, in any case of arbitration of the election of the president, it is the Supreme Court of India whose decision is final. The election of a person as a president cannot be challenged on the ground that the electoral college was incomplete, that is, existence of any vacancy among the members of the electoral college. If the election of a person as a president is declared void by the Supreme Court, acts done by him before the date of such a declaration of the Supreme Court are not invalidated but continue to remain in force. Friends, the above two stated points are very important from the exam point of view. Okay, moving on. Some members of the Constituent Assembly criticized the system of indirect election of the president as undemocratic and proposed the idea of direct election. However, the constitution makers chose the indirect election due to the following reasons. Number one, the indirect election of the president is in harmony with the parliamentary system of government envisaged in the constitution. Under this system, the president is only a nominative executive with the real powers are vested with the council of ministers headed by the prime minister. Friends, had the president been elected by direct election, there would have been a conflict of powers between the prime minister as well as the president, because both have been given equal powers by the people of the country. Such a conflict arose very recently in international politics. That is the perfect example being Sri Lanka, where both the president as well as the prime minister have equal powers as they are both elected by the people themselves, and this led to a conflict over there. Eventually it led to a constitutional deadlock. To avoid such a situation, the foresight of our constitutional fathers was so high that they decided that the president should be indirectly elected. It would have been anomalous to have the president elected directly by the people and not given him any power. The direct election of the president would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic head. Moving on. Some of the members of the Constituent Assembly suggested that the president should be elected by the members of the two houses of the parliament alone. The makers of the constitution did not prefer this, as the parliament dominated by one political party would have invariably chosen a candidate from that party, and such a president could not represent the states of the Indian Union. The present system makes the president a representative of both the union as well as the states. Further, it has pointed out in the Constituent Assembly that the expression proportional representation in case of the presidential election is a misnomer. Proportional representation takes place where two or more seats are to be filled. In case of the president, the vacancy is one only. It could better be called as a preferential election or alternative vote system. Similarly, the expression of single transferable vote was also objected on the ground that no voter has a single vote, every voter has plural votes. Moving on. What are the qualifications, the oaths and conditions? See friends, the qualifications is again very important for the president. A person is eligible for the election as a president if he fulfills the following qualifications. Number one, he should be citizen of India. Number two, he should have completed 35 years of age. Number three, he should be qualified for election as a member of the Lok Sabha. He should not hold any office of profit under the government of India or any other state government or local authority or any other public authority. A sitting president or vice president of the union, the governor of any state, and a minister of the union or any other state is not deemed to hold any office of profit and has not qualified as a presidential candidate. Please remember friends. Further, the nomination of a candidate for the election of the president must be subscribed by at least 50 electors as proposers and 50 electors as seconders. Friends, remember the number of 50. Definitely in exam the question can be asked, though if a question is framed, there is a very high chance of the number being extrapolated to a very great extent. It will not be very near. Okay, every candidate has to make a security deposit of 15,000 rupees with the Reserve Bank of India. The security deposit is liable to be forfeit in case the candidate fails to secure 1/6 of the votes polled. Before 1997, the number of proposers and the seconders was 10 each, and the amount of security deposit was 2,500 rupees. In 1997, they were increased to discourage non-serious candidates. Oath of affirmation by the president. Before entering upon the office, the president has to make and subscribe to an oath or affirmation. In his oath, the president swears to faithfully execute the office, to preserve and protect and defend the constitution and the law, and to devote himself to the service and the well-being of the people of India. The oath of the office of president is administered by the Chief Justice, and in his absence, the senior most judge of the Supreme Court administers his oath. Friends, please remember, definitely this question can be asked as to who administers the oath to the president. Any other person acting as a president or discharging the functions of the president also undertakes a similar oath of affirmation. This is again a very important statement. Conditions for the president's office. The constitution lays down the following conditions of the president's office. He should not be a member of either house of the parliament or a house of the state legislature. If any such person is elected as a president, he is deemed to have vacated his seat in the house on the date on which he enters upon his office as the president. He should not hold any office of profit. he is entitled without payment of rent to use the official residence, that is the Rashtrapati Bhavan. He is entitled to such emoluments, allowances and privileges as may be determined by the parliament. His emoluments and allowances cannot be diminished during his term of office. In 2008, the parliament increased the salary of the president from 50,000 rupees to 1.5 lakh per month and a pension of 50% of the salary per month. In addition, the former president are entitled to furnished residence, phone facilities, car, medical treatment, travel facilities, secretariat office and office expenses up to 60,000 rupees per month. The spouse of the deceased president is entitled to a family pension at the rate of 50% of the pension of the retired president. Furnished residence, phone facility, car, medical treatment, travel facilities, secretariat staff and office expenses up to 12,000 rupees per annum. The president is entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings even in respect of his personal acts. He cannot be arrested or imprisoned. However, after giving a notice of two months, civil proceedings can be instituted against him during his term in the office in respect to his personal acts. Next is the very important topics: his term, impeachment and vacancy. Term of President's office. The President holds office for a term of 5 years from the date on which he enters upon the office. However, he can resign from his office at any time by addressing a resignation letter to the Vice President. Friends, it's very important to note down the terms over here. Resignation to the Vice President, but his oath is taken up by the Chief Justice of India. Further, he can also be removed from the office before the completion of his term by a process called impeachment. What is this impeachment? We will look into that eventually. The President can hold his office beyond a term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms. However, in USA, a person cannot be elected to the office of the President for more than twice. Moving on. Impeachment of the President. The President can be removed from the office by a process of impeachment for the violation of Constitution. However, the Constitution does not define meaning of the phrase violation of the Constitution. The impeachment charges can be initiated by either house of the Parliament. These charges should be signed by 1/4 of the members of the House that framed the charges, and a 14 days notice period should be given to the President, after which the impeachment resolution is passed by a majority of the 2/3 of the total membership of the House. It is sent to the other house which should investigate the membership of that house. It is sent to the other house which should investigate the charges. The President has the right to appear and to be represented at such investigation. If other house also sustains the charges and passes the impeachment resolution by a majority of 2/3 of the total membership, then the President stands removed from his office from the date on which the bill is so passed. Thus, an impeachment is a quasi-judicial procedure in the Parliament. In this context, two things should be noted down. A nominated member of either house of the Parliament can participate in the impeachment of the President, though they do not participate in the election. The elected members of the legislative assemblies of the states, union territories of Pondicherry do not participate in the Pondicherry and Delhi do not participate in the impeachment procedure of the President, though they participate in this election. Friends, one clue or one easy fact for you to remember as far as the exam is concerned: the appointment college as well as the removal college of the President is equal to the electoral college of the Vice President. So if you remember that who all participate in the election of the Vice President, you need not take efforts to remember who all participate in the impeachment of the President. It is it's a trick with which you can very easily remember the electoral college as well as the removal college of the President as well as the Vice President. And also one more very important fact that we all must understand is that no President has been impeached so far. Friends, also see, it's very easy. In both the houses of the Parliament, all the members will participate in the removal college of the President. Also, all the members of both the houses of the Parliament will participate in the election of the Vice President. Next, vacancy in the President's office. A vacancy in the President's office can occur because of any of the following ways. Number one, on expiry of the tenure of 5 years, by his resignation, his removal by a process of impeachment, by his death. Otherwise, for example, he becomes disqualified to hold office when his election is declared void.